little inputs of the last manual we have built for the use of civil society. Of course, it's very different from the kind of manual we built as entitled, but it's another input that we could take in consideration. No? In EJOLT, at CDCA, we have been coordinating the work package regarding law and institutions. So we have been coordinating experts as non-experts, and they wrote lots of reports and analyses, lots of cases of environmental justice into the legal systems in different countries at different levels. And what we tried to do as non-experts was to translate this kind of information into something that was more accessible to civil society or to communities or to organizations working with communities in particular. That was not easy. We had last year a workshop in Rome where we tried to get the first training from the experts to the NGOs part of EJOLT. And since last year we tried to build this report, let's say. I call it a manual. It's more manual. This is nothing about an analysis. This is just the systematization of information. So one of the objectives we had with this manual was to gather and systematize practical information on justice bodies and institutions at international and regional level. So of course, let's say that from this systematizing might be very reductive in the sense that it's something in English, it was supposed to be global, so of course it's not like the main strategic manual of the world, but we tried to get to see which were the institution or the law bodies at international and some regional level that could be used to bring forward environmental injustices into law or institutional bodies. So we focused in particular first on the separation of civil law, common laws and penal laws, trying to give understanding of these two different law systems and how they work.
Can we make it bigger?
Yeah, sure.
Everything else related?
Peut-être abassar a Lucie. So the whole first part is looking at civil law tools, okay? And after a general presentation of what to be understood as civil law, as in different law systems it might not be called civil law. We explain that we use this term in the manual, why, blah, blah, blah. We go through different regional areas. This is not all the areas of the world, of course, because there's not regional justice bodies at this level in all regions of the world. Plus, this is not supposed to be an exhaustive material, but this is a material systematizing information that has been developed throughout the project and with limited expert resources. That is non-expert, dealing with expert materials. So we have been through the European level, through the inter-American area, and through the African regional tools. So as regional areas. And we also have seen some transnational tools and experiences, because sometimes we don't have, let's say, a law body or a law institution or a regional institution, but you have example of cases that has been brought forward from a country to another. So we also have reviewed this kind of strategic approach in some cases. On the criminal side of it, here we have defined a little bit also the criminal law and how to understand the differences, because it depends on the level of knowledge of a community or a movement, but there is sometimes lots of lack of knowledge about this different kind of level. And then we have been to see it from an international point of view, in particular regarding the International Criminal Court, which until yesterday never really dealt with anything that has to do with environmental crime, but actually in October for the first time there has been a demand that regards an environmental crime You might all know the case of the German Texaco in Ecuador. After over 15 or 20 years of legal battles between the United States and then the Ecuador against the company, the legal team has brought a demand to the ECC. The ECC usually tackles crimes that has to do with war crimes or heinous crime in a more traditional understanding. But now they had a demand against the CEO of Chevron because he did not act for the implementation of the court case and should be regarded as such as a crime against humanity. To make it brief, this is an example of how we did. And then we also presented national criminal law, which is completely different in a country and in another, but we tried to give an approach of which kind of information people should gather and should bring forward to a prosecutor, for example, in order to bring attention and to put forward cases. It's very difficult to summarize such work in a short amount of time. Then the last part of the manual regard more a look into defending defenders. So this is more institutional tools that real specific legal tools. But this was we go to understand, for example, at the level of UN, how you can get mechanism at least for the diplomatic protection of defenders. And then on the second part, a view on strategical approach. So after we review all these bodies, not just like, okay, this is the body, and then I will try to make you some examples so you understand the practicality we try to put in this report. We crossed the gathering of information, the links to other more in-depth information with practical cases. So for every body or judicial approach, you have a concrete example to understand what the tools had, what these legal tools had brought already. So it is the understanding of how you can use it and how it has been used. I will try to go. I know it's hardcore to start in the morning, but we will keep on discussing this morning afterwards on legal aspects. So I will take the European example. I'm sorry, I don't want to be European-centric, but it's the most easy one for me right now. So for example, for the European Council, we have first this kind of simplified file card. Okay, what we are talking about, where the court is, which kind of institution it is, how many member states, what it is, this institution, which court this institution has, and some links, for example, here to others, a convention, it is related to this. How legal enforcement work, and what can citizens can expect in this case, it's with the member state through the European Court of Human Rights. So this is the first inputs. We have very synthesized. Then we go more into depth about what are the opportunities, and we did that for every regional body and international instrument we have reviewed in the manual. So what are the opportunities for the citizens and the EJOs to access this justice system? What the result could be expected. And then here we review more into depth some of the conventions that are central in that case for this specific court. How you can practically access, so here's like very practical, okay, so what are the conditions you need to fill a lawsuit to get there, where you can get further information to fill in a lawsuit, and what are the cases that has been done with this specific justice body. And here, for example, you have an example of cases that has been brought to the European Court of Human Rights. So this is, I repeat, the exercise we tried to make was a very practical top-down. So getting out a bit of the academical analysis of what could be the justice systems and how justice systems answers the need for environmental justice, we tried to bring together the two approaches, having a reflection and analysis, and from this analysis having really concrete information and systematized concrete information in one document, because most of the time you won't have practical information, put it all together. So that was a bit the intent we had with this manual, bringing together very practical information all together with further links. So when you get with this manual in your hand, you will see, okay, this could be interesting for me, and maybe I should get to see this particular instrument, and through the links you have and other further material you can accede through the manual, then you can understand how to better pursue. There's lots of limits in this manual. I am quite aware, and I was aware of it before I did it. As I said before, systematizing is very reductive, first of all. We do not pretend to be exhaustive at all with this manual. We know this is just a small picture of the whole picture, but it's the first attempt to have a form of manual that could be then replicated at different levels, from national to regional, on specific issues. That would be maybe a future manual just on defending defenders, for example. And there's the language issues and the dissemination issues. This is a manual which is just in English. We have no fund for making it translated. So far, I don't even know how to translate this in Italian. It's international, so of course, I think for an Italian, using this manual would mean they would look mainly only to the European part of it. There will be some other international instrument, but anyway. I repeat, this is thought as a first step, and from this we are trying to build up also contacts with further institutions, for example, to raise money and to understand, for example, how you can from this build further on to get more into depth in a specific area or in a specific field with such manual, and to really use it as a capacity building material, because the aim was to have something for which from the manual you could do self-capacity building, and you do not need much. Then this is another limit we have with this first material. There is no resources to do a real dissemination, not just in terms to put this on the internet and spread it through emails, but in terms of I print it, I translate it, and then I go around physically to present the materials and talk with local committees on how to use that. It's not so easy, but the potential of this kind of material lays, let's say, in this